right then. Good morning and welcome again to especially those who've just joined us. We will be giving you a really nice roundabout of what's happening in the field. And as you can tell from our title, Securing Mental Privacy, Governing Brain and Neural Data, we have a combination of academic and technical expertise. My name is Eamon Temur, and I'm a PhD researcher at the Tilburg Institute for Law, Technology and Society. My research focuses on AI-based manipulation and cognitive freedom, and I will be moderating today's discussion. This panel will examine how neurotech is moving beyond medical and research settings into everyday contexts, such as workplaces, education, gaming, and in consumer technologies. As these systems become more integrated into social and commercial life, they raise increasingly important questions surrounding neural data governance, mental privacy, cognitive autonomy, consent, and also adequacy of existing legal mechanisms. Today, we will explore questions such as: how should neural data and neural inferences be governed? Are existing frameworks such as the GDPR sufficient? And what happens to concepts like mental privacy and freedom of thought in increasingly inference-driven environments? And we are joined by an excellent group of speakers. First up, we will have Virginia Mayhew from the Center for Future Generations, where she is a neurotech director and is leading work on the governance and societal implications of emerging neurotech. And she will open the discussion by mapping the contemporary neurotechnology landscape and the rise of consumer neurotechnology. And after that, we will have Timo Stas, who is a senior researcher at the University of Antwerp, who will discuss neural data governance and GDPR-related challenges. We will then hear from Jacopo Piemonte, a PhD researcher at VUB, whose work focuses on the legal and regulatory implications of neurotech and brain-computer interfaces in immersive gaming. And finally, we have my colleague at TILT, a PhD researcher, Alexandra Ziaka, whose research examines freedom of thought, privacy, and emerging technologies. And she will conclude the presentations from a human rights perspective. And with that, I would like to invite the first speaker, Virginia, to begin.
All right, thank you very much. Good morning, everyone, indeed. Nice and early, so thank you very much for being here. So at the Center for Future Generations for the last couple of years, indeed, our role is that we've been mapping the trends and the developments in neurotechnology. So looking at how it's evolving, what it's being used for, how it's being marketed and sold, and importantly also how these technologies are being regulated here in Europe. So I'd like to tell you a little bit about some of our findings over the last couple of years and where we see things at the moment. I hope the clicker is working. Yes, it's working. Perfect. Okay, so in very broad strokes, as Eamon already mentioned, you can think of neurotechnologies, if you think of them sort of out of the blue, you might think of medical brain-computer interfaces or medical devices. And that has been true for a very long time. Neurotechnology has its roots in medicine and in research. So you might think of systems for monitoring epilepsy, for instance, using EEG. That's one that people are very familiar with. You might also think of implants that help patients regain motor function, either through stimulation of the brain or through being able to control an external device. These devices have been making huge amounts of progress, particularly in the last few years. Perhaps you're familiar with the cochlear implant. That's also a form of neurotechnology that's been around for a very long time, or deep brain stimulation for Parkinson's disease, as well as a few others. What we're also seeing in parallel is a rise in non-medical applications of neurotechnology, and this is what we call consumer neurotech, and it includes a couple different categories. But it's really characterized by a few different trends. First off, the miniaturization of the technology, so getting it into a more wearable form factor that's more portable, more accessible for the general public. It's also sort of helped along by increases in signal processing. Along with the sort of the tech becoming more wearable, the signal gets a little bit worse, but artificial intelligence is really helping to be able to understand neural data much, much better than we ever have before. So this kind of compensates. And also, if you've ever had an EEG in the hospital, you might think of all the gel that you get in your hair, for instance, because you need that conductive gel to be able to actually measure the electrical signals of the brain. But we also have increasingly dry devices that are able to sort of infer data from the brain or collect neural data without having to use this gel. And that really expands the possibilities for how these technologies can be used and applied in different sectors of society. I have a couple of examples here on the table. So this is a EEG device. This is the Muse Athena. And it has these sensors here, which detect basically the electrical activity of the brain through the skull. And this one is used for sleep tracking and used to help with meditation, to help with productivity and focus and that kind of thing. So as I mentioned, these are general wellness devices, not medical devices, but also have applications in research and a whole different range of things. By the way, I'll just pause and say if I sound out of breath, it's because I'm 7 months pregnant and I'm struggling to breathe a little bit these days. So apologies for that. So one of the main trends that I really want to highlight again is this miniaturization of the technology. And this is really what companies are going in on, is the fact that these technologies can be increasingly wearable and unobtrusive. So we're seeing particularly embedded into headphones and earbuds. So you have a couple of examples. On the far left, this one is already on the market. It's the Eden Guardian. And you see in the middle, you have an example of a patent by Apple that was filed a few years ago to bring brain sensing technology into these earbuds as well as a few others, these really like fancy little, almost like a sticker on the forehead or a little ear cuff that sits behind the ear. These are very, very simple devices, collecting very, very basic data, but I'll get a little bit more into what this data can and can't do in a bit. So yeah, just in terms of some of the most cutting edge applications that we see, one on the bottom left, for instance, is one that I find fascinating. It's a company using basically this device instead of a password manager. So instead of having to type in your password or your PIN code, it just uses your brain signal, which has a sort of a unique signature. You don't even have to do anything particularly, but it can authenticate you using just your brain signals and act instead of your password. This is a startup, which is not yet officially launched, but it's developing this. Meta as well has been doing studies in using, this is actually a very large device, the size of a room, to convert thought into speech. This is a very attractive sector for people being able to type without having to use their hands, but directly from their mind. And we have seen papers proving the proof of principle anyway. This is not yet in a wearable form factor, but it is an important trend. As well as a couple, I'll skip them for these purposes. So I already mentioned Meta, but one very important signal as well is to know that we have seen big tech companies getting very interested in this technology. So thus far, as I mentioned, it's mostly medical companies as well as mostly some startups. However, we've seen acquisitions, investments, and patents by a whole range of different big tech companies, and including Meta, who have actually launched the first major commercially available neurotech device, which is a wrist-worn device, so still pretty, basic. But yeah, you can see all the companies there that are investing in this space somehow. So that's we think that they're kind of waiting for the tech to be mature enough before they make a full move into the sector. So briefly telling you a bit about how the market has evolved. In blue, we have medical companies. And in sort of orange, we have the consumer companies. And what you can immediately see is that there's been an absolute explosion in the number of these companies being founded over the last 10 years. And we have another graph, I don't have it here, but actually you'll see that the number of consumer companies now outnumbers the number of medical companies as of about 2019. So now consumer neurotech accounts for about 60% of all companies globally. Just briefly as well, just to say that, in medical neurotechnology, there are many different types of technologies. I've mentioned EEG already, which is collecting the electrical activity of the brain, but there are many others that stimulate or that use other modalities, like this one is called FNIRS. It's using optical light to measure the blood flow in the brain. Whereas in consumer neurotechnology, it's really dominated by EEG, and that's because it's safe and it's very well known. And there's also some interesting regulatory reasons why. It's because several other different technologies have to be medical devices by law if they're being used, whereas EEG does not. Yes, I think I already mentioned that it's 60%, and that holds across all the regions that we looked at. So one thing I really want to mention that's important is that it used to be that companies would own the whole tech stack. So they would develop the device, analyze the software, and run the app on the phone as well. But increasingly what we're seeing is that those services are being split out across multiple different companies. So we're seeing partnerships between the hardware developer. They create a generic device that is then sold to a company that is going to market it for a particular application. And they have third-party software that they use to analyze the data, and then, et cetera, et cetera. And then you can also have third-party apps that can access the device and, process that data in their own way. So that's, when we're thinking about the data protection, that's an important trend because it means that the data is starting to flow across many different companies, not just owned by a single controller anymore. And the other thing as well that's important to know about particularly consumer technologies is that, as you can probably imagine, if it's a medical device, it's obviously tightly regulated, and there are, clear data protection standards for health data that is collected. However, if they're not claiming to be a medical device, if they sit outside of that, then you have to look at the whole other range of laws that apply to general consumer devices. And that's where things get a little bit complicated, and I'm sure my colleagues will go into a lot more detail. Can't see the screen here. I also just want to briefly say that, so we mapped a little bit the scientific evidence and the claims and the transparency of consumer companies. What we found was slightly discouraging, is that not all companies actually accurately disclose that they are not medically certified. They're not entirely clear exactly about how they're processing the data. And also, almost 40% of companies provide no scientific evidence, this again for consumer devices, that their device actually does what it says it does. It's really a wild west, shall we say, in terms of the marketing and how these devices are being sold. In terms of what they can actually do, this is really, really important because there's a lot of controversy in the field, shall we say, around consumer devices between experts. What a device like this can reliably do is it can identify broad strokes about someone's mental state. So it's not going to go in and read specific thoughts, and there's also a very gray area about emotions. I wouldn't say that this kind of device today is able to make those kinds of inferences. However, what it can do is, again, this is a very clear example that I recorded myself from a colleague in the office. Very easy to do. You can see briefly that these blue waves that are very high indicate that this person was in a relaxed, not quite meditating, but just a relaxed state. And then at about 1 minute in, I prompted them to think about something. I actually told them, imagine you stubbed your toe. And you can see very quickly that the pattern of their brain activity shifted very quickly. Those blue waves came down, and the other waves that correspond to, increased engagement went up a bit. So these are the kinds of things you can reliably record. And I also want to add that this kind of data is extremely easy to analyze today with modern AI tools. So this is just the generic version of ChatGPT, no fancy plugins, no specialization, nothing. You can put this kind of graph into the chatbot window, and it can tell you in broad strokes what kind of mental state this person was in. So in this case, this person, I think, was, thinking about something like, a little bit mentally engaged, but not super focused, but also not quite relaxed. In terms of there's a lot of hype in this field, so it's very, very careful to sort of parse what is sort of marketing hype and what is actual technological capability. I mentioned earlier thought to text. We saw recently a startup that was launched that claims to have, it uses 10,000 EEG sensors embedded into a beanie cap, a hat, and it's claiming that with this, it should be able to convert silent speech in your head into text. Like I said, Meta recently shown this with a machine the size of the room. Can a beanie do it at this stage? We really don't know. They have not provided any scientific evidence yet, but there's a Wired article about it. It's on Business Insider. There's a bunch of different, it's making the rounds in terms of the hype. Other claims, for instance, are being able to control your dreams. Actually, what they're doing is they're trying to induce lucid dreaming. It's not exactly the same thing. And again, there's no scientific evidence to prove that this is actually working yet, but they're already taking pre-orders. So make of that what you will. And finally, one other thing that I really want to highlight is that what is already happening, so this is quite common with these devices, that they'll give you metrics as you use the app over time. Oops, sorry. It will keep track of how your brain is performing, and it will give you these very simplified metrics that tells you about your brain age often, or your cognitive score. And it's not entirely clear how exactly these devices are making these assessments, and it's a little bit debated about if this is really legitimate, and also what impact that has on someone to find out if they're 25 years old and that they have a cognitive age of 50. Is that really is that helpful? Is that accurate? It's a bit of a interesting area. Briefly about the risks that we see. I won't go into too much detail, but you can probably imagine. The first is that, well, particularly with consumer devices, we're concerned that given the lack of transparency, that people might turn to these devices, especially with the claims that they're making, in lieu of actually seeking proper medical treatment. That's one big concern. I mentioned these highly simplified metrics as well. They're not clinically validated. So are they really providing the users with something useful or not? It's very unclear at this stage. I also already mentioned that the fact that the tech stack is splitting out and you have third-party integrations really complicates the flow of this data, and we'll get all into the data sensitivity, of course. I haven't mentioned it, but clearly this data is extremely sensitive. And then finally, this is my sort of little dystopian scenario. I do think that there is a serious potential for, if this data does get hacked or get phished or get used in a way that is not, let's say, aligned with our values, it could really be used in a way that's very detrimental to people's sort of self-determination and decision-making. The examples I typically give are, even detecting something if someone is engaged and paying attention while they're scrolling social media, for example, that's already a really powerful indicator that could help with profiling them and inferring what kinds of things actually they find interesting in the content that they're watching, much more so than just clicking on it or scrolling past it. So that really opens up a whole new frontier if your Instagram is able to read your headphones' neural data, let's say. Okay, so as I mentioned as well, we have been looking at the governance of these technologies, although I'll say in a fairly big picture way. So we have produced a sort of a mapping that shows all the different regulations and policy frameworks in Europe and also abroad that apply to neurotechnology. Although my colleagues will be able to go into much more detail on that than me. So I think I'll just leave with a couple of our recommendations. I'll let those that are taking a photo go ahead. As I mentioned, we've been particularly focused on this gray area between consumer and medical devices. And what I'd like to say is that I think that we're definitely at a time where our framework of calling something consumer and something medical is no longer really reflecting the reality of what these technologies do and how they're being marketed. We have a number of recommendations there, but what I would particularly highlight for this conversation is we recommend mandatory labeling and transparency, especially about how the data is being processed according to a standardized format, because this is really variable right now. Second, we really think that there's an opportunity with the European Health Data Space, which has a provision for wellness data to be integrated into the health record. I think that making effective use of this could go a long way to helping these technologies come better in line, let's say, with data privacy standards. And finally, the other thing that we've heard a lot from these companies is that it's actually very complicated for them to navigate compliance in this sector because we have so many different laws and it's so complicated to understand how they apply to this sector, given that it's very novel. So we definitely need guidance. We definitely need something like a code of practice that companies can help to interpret how to actually comply with GDPR as well as other governance frameworks. I think I'll leave it there. Thank you very much for that. I'll pass on.
So also from me, good morning. Thank you for being here. I'm very glad to be here. Thank you for the invitation, Eamon, and for putting together this panel. I'm going to build further on this wonderful setting of stage that Virginia just presented us with, and I'm going to focus more on the regulatory impact or the GDPR impact of neural data, so the data that is generated by these different technologies.
This is mine, I guess.
I think the PowerPoint indeed is Jacopo's PowerPoint. Yes, there we go. Thank you. So I'm not going to repeat this as Virginia already sketched out the picture very well about how neurotechnology is moving beyond its medical constraints, beyond the context of research, beyond the context of clinical care, into our daily lives through wellness applications, but also in fields like education, like workspace, like entertainment, and so on. So neurotechnology is really moving or penetrating our daily lives in different ways. And that, of course, comes with imminent growth, an ongoing growth of availability of neural data and the processing of collection and processing of neural data. There are multiple definitions of what neural data really is. I'm going with this very general definition of neural data by the TPD, the Council of Europe Commission on Privacy, which is neural data as information derived from the human nervous system, such as brain activity patterns and neural signals. So why, as there are an increasing number of commercial neurotechnologies entering the commercial space in our daily lives, the prospect is that neural data is set to become part of the big data ecosystem. The volume of available and collected neural data is growing. The variety of different kinds of neural data by different neuroimaging technologies is also growing, while of course the main technique is still EEG, especially in the commercial setting. Still, there is a growing variety of neural data available, being processed also by new processing techniques. All these different kinds of devices have their own purposes and rely on their own processing methods, AI-induced, AI-enabled processing methods. So also those techniques are growing in variety. And this ultimately will lead to a cross-integration of neural data with other forms of personal data, primarily, or we can first think of health data and biometric data when we look at those health apps that will ultimately just bring together different forms of health data, such as heart rate data, brain data, that will probably start to bring it all together in more comprehensive health apps. And also the standardization of data forms is one of the goals in order to ensure that neural data can be transferred across platforms, institutions, and different sectors in order to enhance its usability in different fields. So the prospect here is that neural data will become part of the big data ecosystem in the near future. And already in 2023, UNESCO had flagged some concerns about it, about the fact that once neurotechnology enters the consumer market, neural data will become a sought-after data type and will become a commodity beyond the medical sector. Well, and why do we have to care about this? Why is neural data subject of such a vivid debate in the data protection sphere? Well, that's because of the inherent nature of neural data. As Virginia already pointed out, it's a very sensitive kind of data. And there's multiple reasons. It's a combination of different characteristics of neural data that make it so sensitive. But the most prominent one is its informationally rich character. So neural data, as said, is information derived from the monitoring, the recording of the nervous system or the brain in many cases, but it can tell us so much more. And with the advancement of AI-enabled decoding systems, there's a whole, there's so many information that can be derived from neural data. Many different inferences can be made. I indicated some. Health data can be derived from neural data. Does a person suffer from a mental disorder or a neurological disorder, or are they predestined to suffer from one in the future? Behavioral data. Here we can particularly think about predictive data in terms of human behavior. In neuromarketing context, for instance, neural data is used to predict consumer behavior, consumer preferences, and how different consumers are going to act when presented with different marketing strategies. Then neural data can also function as biometric data, as neural data is unique to every individual. Every individual has its own brain patterns, so it can be used as a biometric indicator. And then most importantly, for its sensitive nature, or most distinctive is mental data or cognitive biometric data. Neural data can be processed to reveal something about the mental states of a person, and it can be more general, non-propositional information, such as someone's level of focus, someone's level of relaxation, but it could also really be semantic content. And that's, of course, the science on that is in very early stages, but in different studies show that imagined speech, or some refer to it as thoughts, could reliably be decoded from neural data. And it goes on to include emotions and intentions and so on. And again, it's very much in its infancy, but it seems to be the way that the science is growing. So we don't have to go into the hype of mind-reading devices to make this point. It's at this stage really not yet there, but it seems a clear direction the technology is moving in. So this really makes that neural data can or should be labeled as sensitive data. And we should not lapse into some sort of neuroexceptionalism. Many characteristics neural data shares with other kinds of data, like biometric data, like health data, even like other types of cognitive biometric data, because neural data is not the only type of data that gives an insight into the mental states of a person. When someone would have access to the online activity of a person at a certain stage and combine it, for instance, with other biometric data like eye movement or heart rate, we can also infer what some people are feeling at a certain moment of how they are engaging with certain online content. So neural data is not unique in this regard, but we could say that the combination of all those characteristics together in the form of neural data warrants some special concern. And I would say that the most distinctive in this regard is the behavioral nature of the mental inferences that can be made. So a person does not have to exhibit any external actions in order for their mental state to be inferred. And it is also working towards really semantic content that can be decoded. So not merely someone's level of engagement or fatigue, but really what someone might be feeling or thinking. So in that way, neural data could be said to be really a unique direct correlate to the inner self of a person, to their minds, as some would put it. And therefore, it's important in a data protection context to legally protect neural data as a sensitive form of data. And this was also one of the main points of the UNESCO recommendation on the ethics of neurotechnology, which has been adopted in late 2025. So all member states of UNESCO committed to protecting neural data as a sensitive form of data within their legal frameworks. And there are different instruments within the UN that already came to the same conclusion. So UNESCO is not the only forum where this has been recommended. Also, the Human Rights Council Advisory Committee in its first report on neurotechnology really stressed the sensitive nature of neural data. And the same was done by the rapporteur on the right to privacy. And on a national level, there are different countries in the world, different states in the world that already acted upon these incentives to give special attention to to neural data within their legal frameworks. In Chile, even a constitutional reform has been adopted that in the constitution enshrines the protection of cerebral activity. So that is one way, a very far-reaching and also controversial way to legally protect neural data. More recent initiatives have been taken in the US. Different states, you can see them here, have updated their privacy frameworks, their data protection frameworks to include neural data. And very recently, Canada did the same. They issued an official interpretation of their sensitive data framework as to explicitly include neural data. In Europe, there's a similar commitment, but it is more limited as it is really refrained to statements that have been made by the European Parliament. There's a specific declaration, the Lyon Declaration on Neurotechnology, where they're also underlined the importance of neural data. And also the European Data Protection Supervisor has issued a report in 2024 where they really underlined the invasive and sensitive nature of neural data. But where does this leave us in Europe? And of course, with the GDPR as the main framework for data protection in Europe, what's the status of neural data? Well, we can say that in many instances, neural data will be personal data, so it will fall under the GDPR, as it is by many described as inherently identifiable, since it's unique to every individual. And of course, in an aggregated form, that identification may become more harder, but in general, neural data will often qualify as personal data. Then the question becomes, does it also qualify as sensitive data in the sense of Article 9 of the GDPR? And there, much debate has been going on among experts. The consensus seems to be that it really depends on the context. When neural data is used, for instance, to control a robotic limb, a neuroprosthetic, when it's used in a medical context, also for speech decoders, for people who are paralyzed but can use a neural interface to produce speech, well, then neural data will be health data because it's used in a medical context. The same applies when it would be used for the specific or explicit identification of an individual. Then it's biometric data and will also qualify as sensitive data. But this leaves a whole range of data on not qualifying as sensitive data, and especially in the commercial field where neural data will be used to control an avatar in a game, or will just be used to indeed inform someone on their progress in their meditation, for instance. That's not necessarily health data. So there's much uncertainty there. You could also make the argument that neural data, per definition, qualifies as health data because it always would reveal something about the normalcy or the abnormality of someone's neural activity, which then gives an indication about someone's health, but that's not the interpretation that seems most in line with the interpretation of health data within the EU, so much uncertainty remains. And that's why recently the European Expert Group of Human Rights and Emerging Technologies, of which I am part, we launched a call to make use of the omnibus proceedings to fix this, to bring more clarity to the status of neural data, and particularly to unequivocally acknowledge that in every situation, neural data should be treated as sensitive data. And we proposed three possible ways in which this could be done, that neural data will in every instance be sensitive data. There are three options for small tweaks of the GDPR that would enable this. And very briefly, we'll touch on them. The first two will revolve around the notion of biometric data. So here we propose that we should harmonize the definition of biometric data within the GDPR and within the AI Act, because today, as it stands, there are different definitions. the GDPR requires an intentional aspect of the intention of identifying a person, while this intentional aspect is fully absent in the GDPR. So we would propose to adopt the definition of biometric data in the GDPR, which would make that neural data would always qualify as biometric data. And then there would be two options, or in Article 9, we add that biometric data not only to identify a person, but also to infer mental states of a person would qualify as sensitive data. Or you could also, in a second, more profound or more far-reaching option, we could also just remove any qualifier for biometric data within Article 9 GDPR, that biometric data as such would be an sensitive form of data. And those two would make that neural data, when it's used to infer mental states in the first option, or all neural data in the second option, would qualify as sensitive data. And the third option is the most easy option, that would be just to include a definition of neural data in the GDPR and list it in Article 9.1 as one of the sensitive forms of data. So we think this digital omnibus process is a good opportunity to solve this uncertainty, this lacuna in the GDPR, and really acknowledge the status, the high sensitivity of neural data in our data protection framework. Now, we also recognize that this, of course, does not fix everything. The sensitive nature of neural data, recognizing it does not fix every concern we have. There are many challenges that neural data poses to the framework of the GDPR as it stands. For instance, data minimization is hard to do when we have a cap on that keeps on measuring every brain activity continuously throughout the day. There's much redundant data that those devices will capture that are not needed for the purpose that is stated. Other challenges are informed consent, and that's not unique to neural data either. When we have these complicated ways of processing enabled by AI, it's very hard to be transparent to users how these devices really work, how their data is processed, and what the ultimate outcome might ultimately be. So transparency and informed consent pose profound challenges. The same goes with data accuracy and data subject rights. I will not elaborate too much on this considering the time. But even beyond the classification question, there still remain many challenges to the GDPR by neural data processing that need to be addressed. So what's the action ahead? Well, I would say that there are three main points that we should consider. First, an unequivocal recognition of neural data as sensitive data is an easy step to take, but a very needed one. Then we should assess the adequacy of other existing safeguards, such as informed consent, etc. Are they really fit for the purpose that they are set to serve in the context of neurotechnology? And then a more far-reaching action could be to consider whether there would be a need for strict targeted prohibitions. We see in the AI Act, for instance, that Europe did make some hard prohibitions, for instance, on emotion recognition, which also relates and is also very relevant in this neurotechnology sphere. We should think whether similar targeted strict prohibitions that are really narrow might be needed to protect the freedom of our inner sphere, of our inner selves. And then this is a little bit of a recapitulation, but the OECD already said in 2019 that it's very crucial to protect neural data within the whole neurotechnological innovation project. Europe cannot lag behind, and the digital omnibus might present itself as as an ideal opportunity to take on this challenge right now. I'll leave it here, and thank you.
Waiting for the PowerPoint. Okay. Thank you. Good morning, everyone. Thank you for having me, and thank you very much to Ayman for the organization and the coordination of this panel. So, In this case, I have the luxury of having heard the first two interventions and let's say to have totally agreed with the stances which were raised so far. So when preparing basically this panel and this discussion, I've decided and we've decided together to try to stress test this kind of technologies in a way to understand how the legal framework and the current status of the GDPR may play indeed a role in, let's say, understanding that there are some uncertainties when it comes to regulation and challenges that those technologies can put on the market. So I will take into consideration in this brief presentation the possibility to use the neurotechnologies in the gaming industry, and let's assume in the metaverse. So this is, of course, a very promising environment where these kind of technologies may develop. Why it is so? Of course, the user might be given as the possibility to have an immersive experience. And by way of simplification, and here, of course, I'm also speaking under the control of the experts and under the control of Virginia, we have said that, of course, by way of thought, at a certain point, the users might move in the gaming setting and in that environment by way of thought, as I mentioned, without the need to have a joystick or a keyboard. Then, of course, as the technology moves forward, we might have also haptic interfaces, which may allow us to have also the tactile experience. But of course, this is a matter for another panel. So how these technologies are that promising in this industry? Basically, we might have, in particular, brain-computer interfaces, which are sustaining this industry. Brain-computer interfaces, the rationale is the same one as brings a paralyzed person to move the arm. So there is a neural signal which is intercepted. That neural signal is, let's say, converted into a command, a digital command, which is transmitted to a device, and the device allows the movement of the paralyzed person, but also the possibility to move in the metaverse for the user, which is using a brain-computer interface. Then, within this technology, we can divide the brain-computer interfaces in passive ones and active ones. The passive one probably are the most interesting at this moment. So, as we heard before, there are certain brain patterns and there are certain areas of the brain which, let's say, if mapped correctly, can make us understand whether a person in a specific moment is feeling tired or is feeling well, relaxed, and so on and so forth. Then the neurotechnology and a simple consumer device which is used by the consumer, in this case the one who is playing a specific game, may intercept indeed that feeling. It may, for example, intercept the fact that the user is quite stressed, is fatigued, and then immediately the immersive setting in which the person is already plunged can get a relaxed setting so that the user can move forward and play in that dimension for hours and hours, creating even more addiction than the one that the app and the mobile phones are already creating. In this case, of course, as we can see, we have a mapping of states, as you correctly mentioned before, that is to say, I'm fatigued, I'm stressed, so on and so forth. So surely we have neural data which have been processed, and we have to understand how we can interpret, under legal point of view, those neural data. There is the possibility, and of course here the experts must work with academics, lawyers, and so on, to understand whether those neural data are biometric, whether they can be identifiable to a specific person. I understand that this is debatable. It is not certain, so we should, in a way, move forward and try to understand whether instead, in order to have the full coverage of Article 9 of the GDPR with the additional safeguard attached, we might consider those data as health data. In this case, there are some authors which have, let's say, made some interesting arguments in accordance to which we could consider those data as health ones, given that at the end of the day, the mental state, there would be kind of a mapping of a mental state, and also on the basis of some recitals of the GDPR, we might say that the mental status mapping basically brings us to health data. So in this case, with an interpretations like such this one, we might conclude that maybe those kind of data, we might argue that enter into the Article 9 of the GDPR. But moving forward with other technologies, such as the active brain-computer interfaces, which are probably the most promising in the near future, I'm not quite sure that we are already there, then Virginia might tell us, but let's say I understand that there are very good potentialities on that. And these are the technologies which allows, in this case, to the player, so to the user which is using a video game, to move without having a keyboard in the virtual space. And in this case, neural data would be intercepted. Of course, there would be the need to make a specific training before on the train to understand which brain pattern would be associated to the possibility to go right and to the possibility to go left. In the moment in which we have run this exercise, and so there is the possibility to have understood those specific brain patterns, then we will have the possibility and the full possibility for the player to move in a virtual environment without talking, but without, let's say, managing a keyboard or a joystick. So if this is the case, the neural data which are intercepted are neural data which are referring to simple movements around, that is to say, to the possibility to go right or the possibility to go left. In this case, probably, unless we consider those data as biometric, given that they can be, let's say, associated to just one person, unless we do this operation, then it would be probably hard to say that those data are health data, for the fact that in this case, there is no mapping of a mental state, but there is the simple consideration that by way of that operation, the person could move in the environment. But again, we would have difficulties in time in stating that those data are health data, and then they might be encompassed under Article 9. So here we have a plastic demonstration, so to say, of what was saying just a few minutes ago, Timo, about the fact that the interpreter, the one that has to understand these neural data, have to be considered as health data or not, might be triggered with a situation of uncertainty, and it will not be clear whether all those data might be already be encompassed under Article 9. So this is the first gap which probably we might find in the GDPR. The second one, I try to stress test also the consent framework. And also in this case, we are faced with a possible problematic, that is to say, the user, in this case of the video game, would be probably proposed a privacy policy when it's starting to play, and probably there would be at that point a request to provide a consent. And if we consider, for example, the active brain-computer interfaces, that consent would be, let's say, finalized to get its consent for using that technology for moving in the metaverse or in the virtual setting without using the joystick, and that is it. But afterwards, as we have heard also by Virginia, those data which today are used for that specific purpose, in the future, maybe together with other big data and so on and so forth, may be used for other uses. So the point is to understand whether a specific data which was, let's say, gathered in a specific moment, in a second moment could be used for another purpose. And also here we have a demonstration about that and a possible example. So we have a consent which is being gathered for moving around in the metaverse. So let's say here the user gives consent to get this technology on the basis of which the brain patterns are mapped in order to get afterwards his possibility to interact in the metaverse. But after that is given this consent, in the near future, it might be possible that those data used together with other ones might bring to other possibility of use of those data, such as the categorization of the person, or probably also the, let's say, possibility to infer from that data together with techniques of machine learning and so on and so forth, specific future behaviors that that person can take, and so on and so forth. So here we clearly might have a problem, and we might be faced in front of two possible situations. The first one is that we have a controller who basically tries in as much as possible to stretch the privacy policy and the consent which was given at that time in order to reuse those data and say that the purpose which is now used is still compatible with the previous consent which was given. Of course, this would be made under his responsibility, but then we know how difficult it would be for the data subject to, let's say, start a dispute against the controller and show that the consent which was given for something then has been totally disregarded. So this is the first scenario. The second scenario that we might face is that we have a controller which is particularly diligent and continues every time that there is a new use of neural data to propose updates to the privacy policy, and continues to propose new consents to be signed to the user, with the possible consequence that we might have the so-called consent fatigue. The user at that point, faced with continuous request of consent, just decides to move forward without knowing what is really consenting to. And this just in order to move forward with the game and the immersive experience that is living in that specific moment. So just drawing the conclusion and putting 2 points on the table which might be helpful for the discussion and which are totally in line with what Timo just stated. So we might have two possibilities, actually. The minimal solution would be that to try to include the neural data and consider them as sensitive data to cure, and the proposal which we just heard went absolutely in that direction and should be totally to be upheld for what it counts. So you have my support there. The second one, of course, we might also want to consider that probably we should, in a way, move also beyond the GDPR for certain points. For example, the consent framework, we have seen that probably is not working that well with regard to these neurotechnologies. We might consider also further possibilities which might be explored, such as, for example, the prohibition to commercialize neural data. That would be one possibility. Or at least a limitation to be brought to the possibility for the controllers to transfer those neural data. We have heard before that now these neurotechnologies, let's say, determines mass part of the time massive transfers between one controller and the other. So this probably should be regulated, and specific safeguards should be. That was basically what I wanted to state, and I thank you very much for your attention, and I leave the floor to the next presenter.
Perfect. Hello from me too. Jacob, I think I'm the luckiest in the room because I have heard all of your presentations. So now, after having heard about the topic, after hearing so many perspectives, we will focus on the human rights perspective, so mental privacy and neurotechnology. As the previous speakers mentioned, initially neurotechnology was developed in order to further clinical medicine, scientific research, and indeed we have seen that it has advanced a lot health. We have multiple examples. But we see like an increasing trend of using neurotechnology in many different areas, like in everyday life, education, workplace, entertainment, as Jacopo said, even dating life. So like EEG headsets, promising recruiters to find the most appropriate candidate based on neuroprofiles, earbuds, etc. So a lot of examples, and as we heard like the past hour, neurotechnology is something that we cannot turn our blind eye to. I will explore the right to mental privacy through the lens of two existing human rights. Nowadays, there is also, like some scholars have suggested, the introduction of a new neuro right to mental privacy. But in this presentation, I want to explore whether the existing rights that we already have can help us protect our mental privacy. I will start with the right to privacy. Right to private life, of course, we all know about it. So about the mental privacy, there is no commonly accepted definition. There are many different definitions there, but let's agree that it is commonly understood as having control over who has access to our mental states. There are a lot of risks, as mentioned by the previous speakers, misuse of neural data and related inferences, repurposing of processing, as Jacopo said, hacking, sharing with third parties and national authorities. There has been a seminal study of the Neuro Rights Foundation 2024, which examined the data practices of 30 consumer neurotechnology companies and actually found that more than 66% of companies share these data, the collected data, with third parties, which is particularly problematic. Now, about the right to privacy, as we know, it's a right that receives qualified protection, meaning that an interference can be justified if the conditions set by law are fulfilled. So it has to be provided by law, it has to pursue a legitimate aim under ECHR terms like protection of public safety, national security, and of course being necessary in a democratic society. So that means that, for example, it can be argued that in ticking bomb scenarios, we can have access to somebody's mental data and the interference can be justified. This is argued in the literature. Moving now to the second right, like the right to freedom of thought. So this is a different right. It's protected together with these sister rights, the freedom of religion and freedom of conscience under Article 9 ECHR. This right is generally considered to have three substantive negative freedoms. So the freedom not to reveal one's thoughts, so this is connected to mental privacy, the freedom from thought alteration, and the freedom not to be penalized for one's thoughts. The problem with the freedom of thought is that there is not a commonly accepted, again, definition of thought in international law. There are three main approaches that we see in the literature. The first one is the narrow approach, according to which thought includes thoughts that are related to religion. This is a kind of outdated approach, I would say. A moderate approach that the European Court of Human Rights seems to side with, that includes thoughts that have a seriousness, like a cognitive level and an important impact on our life. So it would include, for example, political opinions, philosophical beliefs. And then there is a broad approach that includes all kinds of thoughts, thinking processes, emotions, intentions, dreams, any kind of trivial thought. And it seems that now the majority of scholars, as well as the human rights committee, tend to adopt this broad approach. And I also adopt this approach, so the broad one. Now let's go back to the negative attributes of the right to freedom of thought. As you can initially understand, all of them kind of are triggered, can be triggered by neurotechnology. The first one, the freedom not to reveal one's thoughts, has been interpreted as encompassing mental privacy, and it's actually considered one of the core attributes of the right. So Neurotech, as we saw from the previous presentations, enables the creation of very sophisticated psychological profiles that are based on neurodata, but also biometric non-neural data, voice recognition, typing dynamics, our interactions, for example, on social media, etc., and can reveal, can infer, can lead to the inference of our mental states. There are several studies showing that how neurotechnology can be used to infer political beliefs or even sexual orientation. So this is particularly problematic when it happens without our consent. And what I argue is that the freedom not to reveal one's thoughts is quite important, like, so mental privacy, because it kind of, in interference with mental privacy, kind of enables the interference with the other two negative attributes. And I will explain what I mean. Having access to our mental states can enable the interference with our freedom not to have our thoughts altered, because when we have surveillance, for example, this can lead us to modify, this can lead to the modification of our thoughts, because, for example, McCarthy Jones has suggested that we feel this conformity pressure, that we need to conform our thoughts and our behavior towards what is accepted since we are being surveilled. And this can further lead to self-censure of our thoughts. And then when it comes to the freedom not to be penalized for one's thoughts, consider, for example, when brain imaging is used in court proceedings in order to and as a tool of evidence in order to understand whether the defendant has guilty knowledge. And this has happened actually some years ago in a court in India, where they used neuroimaging methods, showing to the defendant pictures from the crime scene, and they understood that she had already seen that the crime scene, so they based their decision to convict her based on that she had memory of the crime. It can also be in other cases where, like in the workplace, where inferred thoughts, based on inferred thoughts of employees, this could have a negative impact on them. Now, about the freedom of thought in general and why I focus my PhD on that, it's a very important human right, because it's, as you can understand, freedom of thought is considered to be like the basis of a democratic society, basis of other human rights. But despite its importance, is often characterized as a forgotten right. There's hardly any case law about it. Recently, scholars have started working on it to do some work, but still there's not a lot there, which makes it particularly challenging. Despite its importance, so we don't have much in practice, but the importance lies in the fact that it's absolutely protected. So contrary to the right to privacy, freedom of thought is one of the very few human rights, like the prohibition of torture and human degrading treatment, prohibition of slavery, that receives absolute protection. And what does this mean? It means that the moment you have an interference, it cannot be justified. We have a violation of a human right. This is part of the reason that the right is a bit practically difficult to deal with, and that is why scholars such as Leithart and Van der Poel, Bublitz, and Hertz have suggested to adopt the minimum threshold of severity that we already used in Article 3 and Article 8. So when we have a treatment that reaches a minimum level of severity, it can qualify as human degrading treatment. Otherwise, it falls under Article 8. So something like this, by analogy, they have suggested that can be applied in the relation between freedom of thought and the right to privacy. So through my research, I have understood, as I told you before, that the mental privacy attribute of the right to freedom of thought enables the interference with other freedoms. It also opens the door, that's why I name it like a gatekeeper right, to the violation of other human rights. So, for example, freedom of expression. When we feel that we are surveilled, we end up self-censoring ourselves. Equality and non-discrimination, like inferences about our inferred thoughts and mental states can end up having a discriminatory effect on us. The right to work, other human rights, right to health, for example, inferred suicide harm thoughts can lead to us not receiving an insurance or having to pay more for our insurance, for example, right to education, right to fair trial, or inhuman and degrading treatment. And that leads me to the final remarks. Back in 2021, the then UN Special Rapporteur on Freedom of Religion had published the first ever UN level report on freedom of thought. So there, he said, Ahmed Zahid, that the freedom of thought, we should consider it as including as well a positive attribute, a positive obligation to create an enabling environment for freedom of thought. And I tried to group like the different categories of positive obligation of states and come up with some suggestions for neurotechnology, the topic we're discussing today. So the first one is the obligation to provide an appropriate legal or regulatory framework, and this includes actually many of the things that you already said about regulating neurotechnology, establishing protection of neural data's special categories of data, establishing due diligence obligations for neurotech companies that develop, design, deploy, use neurotechnologies, conduct, like next to a data protection impact assessment, conduct a human rights impact assessment that has a broader overview of the impacts of human rights that neurotechnology can entail. And in that respect, for example, Bublitz has suggested, Christoph Bublitz, the conducting of mental impact assessment, I meant the cognitive impact assessment. But the measures that states can take, then can fall under this positive attribute, are not only of a legal nature, can be also of education nature, of administrative nature, so more practical measures. For example, ensuring digital literacy skills of users of neurotechnology, so to be able to understand better what are the impacts, what the data are collected, etc., and fund research about the impacts of neurotechnology. And I think the most important aspect of this positive attribute is that the positive obligations for the enjoyment of other rights should also be respected, because the enjoyment of other rights, like the right to education, freedom of expression, access to information, right to health, enable the enjoyment of freedom of thought, and consequently right to mental privacy that, as we said, interpreted as being included under the right to freedom of thought. I have included a paper of Jan Christoph Bublitz. There's not, as I said, like a literature on positive obligation, so this is was published like very recently, and you can find more information about positive obligations on Neurotech. And that would conclude my remarks. And just to add, we are organizing a conference on law and tech, Tilting, in Tilburg in June 17 to 19. So all of us, Virginia, you're most really welcome. We have 3 sessions at least talking about these issues, so we can continue our discussions there. You can scan the program. Thank you very much. Oh, yeah, sorry.
Yes, so you can see the QR code there, and thank you to the speakers. We have only 5 minutes left, so I'll just open the floor for any questions that you may have. Yes. Do we have someone who can bring the mic? Oh, I'll just...
Just a question, because in the presentation you referred to neuro rights and if they can be classified or not as health data. But then in the same discussion, you say that, for instance, this kind of information, we can say, used to move object can be also reused for further purpose combined with other data and infer mental status. And the second point that is not mentioned, but in the World Health Organization, as defined as health in a very broad sense. So if we combine inferences that can be extracted with the match with other data and the broad definition of health data, is it possible to say that we almost agree that in many cases we have health data and so should be regulated under this kind of label? Just a mix of different sources that should be maybe considered in a broader context. Just a comment.
Yeah, I'll briefly just want to just confirm what you said. Indeed, there is very much a case to make, a logical case to make, that neural data in every instance would qualify as health data, just because of the fact that the inferences at any stage that can be made from it would almost inevitably point to someone's health or sickness on a neurological and neuropsychiatric part. On the other hand, the same could be said about heart rate data, would also almost always indicate whether the heart rate is a normal one or an abnormal one, would indicate cardiac health, cardiac disease. And it is established interpretation of the GDPR that heart rate data does not, per definition, fall under health data. So there's the element that the argument logically seems to point towards the labeling of neural data as health data, but whether or not it will be interpreted that way by courts or by the data supervisor, European data protection supervisor, that's a different question. So that's also why we propose to really make sure that it's clear that it's in every instance sensitive data.
Okay, so maybe we have like time for two more questions. So one and another one.
Thank you very much for this very interesting panel. Panamakratapai from Estonia. Actually, it was mentioned that there is no clear definition of privacy of certain fundamental rights, and that could be a problem. I myself thinking of maybe it could be more of an advantage, speaking about if there's a gap in fundamental rights protection, thinking of neuro rights. We see it also with data protection. Actually, that fundamental rights are so broadly worded has helped us always to cover the whole range. For example, privacy, also there came data protection, could have least included there, autonomy, human dignity. I think it may be also an advantage, because if we want to write down a fundamental right to mental integrity, for sure in 2 years we will have some technological, I don't know, then issue with that, and we will again have to amend the regulation. Thank you.
I can briefly reply. Thank you very much for your question. And yeah, I agree with that. And I think that in that respect, the living instrument approach, for example, the European Court of Human Rights, helps us because, for example, yes, the right to private life has been evolved since the adoption of the European Convention of Human Rights. And that's what I also want to show, that we can use what we already have as a human right and then interpret it, like expansively, so that we can address the challenges posed by novel technologies.
Great, and one more question. Anyone has a question? If not, we can all...
Can I just add something briefly to that? I think I'd just also like to add a practical dimension to both of the questions, which is that particularly when we're talking about consumer devices, these are not validated by any kind of authority before they go onto the market, right? So that's also one of the problems, is that they're self-CE marking before they then, that they are compliant with XYZ, which means that right now we have, basically it's up to the companies to determine how they classify their data, and it's up to them to decide, and there are strong incentives for them to classify that in the sort of the most permissible way possible. So that's exactly that. I think, I won't get into the technicalities of the definition itself. Of course, I agree with my colleagues here, but there's an implementation gap right now between how we interpret the rights and then how they're going to be protected and litigated, etc., and what the companies are currently doing, because the field is moving so quickly.
Yeah, but this was exactly the observation. So it was exactly the observation. So all these revolve around a very limited view of health data. So health data as defined by medical device regulation, or health data as you mentioned in terms of pathology. But if you look at the World Health Organization, the idea of health is much broader. It's not just pathology. And so, and it's not just health devices. So if we move from this perspective, maybe it can be also have a broader interpretation about what it means health data. Because these are narrow interpretation related to specific, context-specific regulation that makes sense that a medical device, there is a specific definition, but the definition is the result of the field. It's not the origin of the concept. Thank you.
Oh, well, thank you for that. I think maybe one last question. We're already over time, so very quickly.
Thank you very much for the excellent panel, really interesting. So I want to comment a bit on this, because indeed these are digital devices, software and hardware. In principle, they are regulated by the Cyber Resilience Act that imposes some cryptographic mechanism to protect the data that will flow through these devices. And because the cryptography now is evolving, my unit at the Commission is trying to ensure the best future algorithm to protect data. And I understand that health data, biometric, whatever, this type of data, on which I'm not expert, of course, they need a stronger cryptographic algorithm. Now, we are doing that also for the larger field of Internet of Things. So this is, these devices are part of sensors that can be seen in the larger field of Internet of Things. So I want to ask you, because you, okay, until now I just made the statement, but just wanted to say, are you in contact with someone at the Commission with the more technical, let's say, anchor on the devices, on the software? Because I would really be interested in starting a conversation with you in order to ensure that the best algorithmic schemes from cryptography are applied to this field in order to protect the use of data. So are you already in contact with someone more grounded in technical,
Virginia, maybe?
technical things?
Shall I answer that? I'd love to be. We've been trying to sort of reach the right people, and we've had a few contacts, but we haven't managed to identify the right person, actually. And this is also one of the things that we've found a little bit challenging when it comes to neurotechnology. There's no real clear home for where neurotechnology sits within that we've been able to identify anyway. So if you have a recommendation, I'd love to chat.
Yeah, it's my unit. So in my unit, we have the big e-brains project. So probably you have heard about e-brains. And we also do cryptography. So I think that there is room for collaborating in the future. I would love
Fantastic.
Well, this is amazing. This is what CPDP is all about. On that note, thank you all for participating and for being here. And thank you for the amazing presentations. And we will see you next year, hopefully.